Hey guys, this is John Watts. I'm a consumer protection lawyer. I want to share with you 2 points from a recent case. This came out of the Middle District of Florida, out of Tampa, and it's called the Weeks versus Equifax, TransUnion, and Truist Bank. Now, actually, it has nothing to do with Equifax right now, but in this order, the judge throws out the claims against TransUnion and Truist Bank. Now, I'm not going to go through this whole case. It's a pretty lengthy decision. You can read it on your own, and it has to do with what are called pay status cases, which I don't really bring. But let's look at two significant points. The first is, and let me just describe it, and then we'll look at the actual language. Sometimes either the consumer or the credit bureau or the data furnisher, like Truist Bank here, will say, the reporting from the consumer standpoint, they'll say, well, the reporting is accurate, but the way some scoring company processes that or uses an algorithm hurts me. So therefore, even though the information is accurate, because it hurts me or a scoring company improperly uses it, then that means the FCRA Fair Credit Reporting Act has been violated. That's been rejected. Well, the flip side is true. What if we point out there are errors, so an inaccuracy, incompleteness in my credit report, and the credit bureau comes back and says, well, yeah, maybe that's true, but judge, look, this actually helps his credit score, or this doesn't hurt her credit score. Well, see, we don't care about the score. The score really goes to damages. The score does not go to whether or not the information is accurate and complete. So let me show you this quote. And this is from a case called O'Neill versus Equifax, as I recall. And this is from the Southern District of Florida. And here the judge in that case is saying that when the plaintiff, the consumer, is saying, yeah, but the scoring algorithms, they say that ignores 11th Circuit case law. 11th Circuit is Alabama, Georgia, Florida. And 11th Circuit's decisions instruct lower courts to consider objectively reasonable interpretation. This is the critical part here. How third-party companies choose to utilize algorithms to decipher the accurate information reported by defendant has no bearing on the accuracy of the report itself. And I would say the same thing is true for things that are complete or incomplete. So if the information is accurate, it's complete, then whether FICO does a great job analyzing the data or a terrible job doesn't change the fact that the credit bureau, if it's reported accurately and completely, it's done what it's supposed to do. Okay. But the flip side, okay, so if the credit bureau say, well, don't worry about these errors we have on here because they actually hurt you, or they don't hurt you, they help you. Well, again, this can be helpful to use because we have to distinguish and sort of pull apart. First, is the information accurate? And if I did a dispute through the credit bureaus, did they do a proper investigation? Did the data furnisher do a proper investigation? Then second, we look at damages. Okay, now that we know that it's incomplete or inaccurate, you did a lousy job investigating, did that hurt me? How did that hurt me? Those are two separate things. So I wanted you to see this. And then this is something that we've kind of ranted and raved about for many years, and I still see people doing this and lawyers doing this. And so what happened is the plaintiff in this situation said, well, here's a three-bureau or a tri-merge report. Now, some people consider tri-merge to be only like your mortgage broker who pulls from a company that pulls the data supposedly from Equifax, Experian, TransUnion. The court here is using this expression even when it's one of the big credit bureaus. So Experian, who says, well, we'll sell you the data for Experian, Equifax, and TransUnion. And so notice what the judge is agreeing with. As TransUnion points out, this, the tri-merge, is an Experian three-bureau tri-merge report, and as such was not issued directly by TransUnion or Equifax, and is missing certain pertinent information. This argument is well taken. The court will not consider this exhibit. And then it says, look at this previous case. In a ruling on a motion to dismiss, district court may consider an extrinsic document. So the context here is this is what's called a a motion to dismiss, normally we don't look at other documents. But it's saying you can look at it if those documents are central to the plaintiff's claim and authenticity is not challenged. Well, here, TransUnion is challenging the authenticity of this so-called tri-merge report. And then here's this case from 2003. So this is not new law. This is from, 19 years ago. Determining plaintiff's FCRA claim failed because why? They have no evidence that an Experian report was seen by a third party. Let's look at sort of the parenthetical. As opposed to a tri-merge report, which Experian did not issue. So again, I just want to continue to hammer home this point. If you want to know what Equifax says, go get your report from Equifax. If you want to know what Experian says, get your report from Experian. If you want to know what TransUnion says, get your report from TransUnion. Do not shortcut this. Do not say, well, I'm just going to go to TransUnion. They'll tell me what Equifax says. No, that you give Equifax an absolute way out of this where they go, that's not accurate information. That's not what we reported on yet. And why give them that argument? Particularly because you can go to annualcreditreport.com, get your real reports. You can go to myequifax.com, get your Equifax report. You can go to Experian.com, sign up totally free, get your Experian report. Now with TransUnion, I am not aware of a way to get TransUnion for free other than going through annualcreditreport.com. But that's a great way to get it. And then look at this last case from 2021. Rejecting plaintiff's reliance on a tri-merge report as the sole basis for his FCRA claim because the tri-merge report alone did not demonstrate the defendant CRAs, those are the credit bureaus like Equifax, Experian, TransUnion, actual credit report contained an inaccuracy. So when we bring a case with a tri-merge report, we're running the risk that the other side will say, hey, there's actually some incorrect data. And I'll tell you this, when I look at certainly credit monitoring, tri-merge reports, when I look at even like here, an Experian that says, hey, we have the TransUnion Equifax, and it'd be the same if you got it all from Equifax or all from TransUnion, if you got all three bureaus. Then if you compare that with the individual reports, there is always different information. There's missing information because they're trying to make these tri-merge reports very easy to read, very understandable. And so they want everything to be sort of consistent, the way that it's described. And these are three different reports, and it's just not the same thing. So it's fine to get a tri-merge, but I would always recommend if you're going to dispute something or if you're going to bring a lawsuit, go get the actual report from TransUnion, Experian, Equifax. I may have told this story one time. When I was in law school, we had a class called Evidences. And Evidences really relates to primarily the rules of federal rules of evidence. And so that's typically what we learn, or very similar state law rules of evidence. And so we learn by going through cases, just like we're doing in this video and in other videos. And but we have these literal rules of evidence. So it'll be like Rule 403 or Rule 106 or whatever it may be. And the way law school typically is done, the professor will call on somebody and sort of question that student while we're going over a case, just like we're doing right now. And the professor happened to know that the court misquoted, just a typo, the rule of evidence. And so while the professor is questioning the student, professor says, hey, go ahead and read for us what, Rule 106 says. Well, instead of pulling out her rule of evidence book, she's looking right at the court decision. It gives the quote, just like we might go through this opinion and find the quotes from the Fair Credit Reporting Act, and she reads it. And the professor in this sort of big booming voice says, young lady, if you're going to quote scripture, don't read from a commentary. And his point was, if you want to know what Rule 106 says, go read 106. Don't rely on what the court says about it. Don't rely on what anybody else says about it. And that same principle is true here. If we want to know what Equifax says, go get Equifax. If we want to know what Experian says, go get Experian. If we want to know what TransUnion says, go get TransUnion. And I know I've talked about this before, but we just see it over and over and over. And what it's doing is it's sort of like saying, well, I'm going to play in the Super Bowl, but I'm going to intentionally limit myself to 10 players on the field instead of 11. Like, why would I do that? Why give these credit bureaus who are horrible and these furnishers which are terrible, why give them an advantage that they don't need, they don't deserve? Okay, make them, play you straight up. And so that's why, again, I'm going to get off my soapbox, stop talking about this, at least for this video. I make no promises about the next video. Go get the actual reports from the actual company, and that will give you the best chance of success. And sometimes we get those reports and we say, oh, well, the reporting is accurate, it's complete. Okay, well, then we don't bring the case. But you need to know. It does no good to not know what the actual data is until you get into the lawsuit. There's some things we can't find out until we get in the lawsuit, but we can find out what our credit reports say. Annualcreditreport.com. Okay, guys, thanks for watching this, and I'll catch you next time. Bye-bye.